Our next speaker is Steve Fogg, a partner at Corr, Cronin in Seattle. Steve also is a former prosecutor and an SEC attorney with more than 80 cases tried to verdict. This year, Steve was recognized by his peers in the nationally known publication Best Lawyers in America and has made Seattle's top lawyers list for the past several years. Steve focuses on complex, high-stakes commercial litigation and trials. His cases include the defense of securities and other class actions, product liability litigation, and other serious lawsuits. Here to kill you with his legal prowess, please welcome Steve Fogg.
Good morning. I'm here to talk to you about the topic that I selected was non-compete litigation. And why did I choose that topic? Very aware that most of you are in-house counsel. And if there is a fact of life of being an in-house counsel, it's that at some point you're going to handle employee non-compete litigation. If you look at the statistics, I mean, they sort of speak for themselves. These cases, published decisions have tripled in the last 20 years. Survey of general counsel like yourself say this is a top 5 hot button issue. And it's really no surprise when you think about our own profession as lawyers. Lawyers don't stay at the same firm for a career the way they have in the past, and employees don't either. So it's something that at some point you're going to deal with. A second fact of life is that you're likely to be on both sides of the litigation. And where I practice in Seattle, we have certainly seen that, where with the spike of these cases, you find yourself on both sides. One year, it's your employee who's walked out the door with that customer list in their back pocket. The next year, it's you who you may have hired an employee or a set of employees who are subject to a non-compete. So I thought the way that I would structure my talk today was to talk a little bit about the differing perspectives that come from being on both sides of these cases. Let's start with, in the first half of my remarks, when you are enforcing a non-compete. And I think it's important to remember, and any of you who have been in these cases, you'll know viscerally, they're very emotional. I mean, there's almost an element of, you know, my wife or my spouse left me. The business person will be in your office saying, we can't believe, you know, we have a non-compete, we negotiated for the non-compete, and the person has left anyway. We want you to do something about it, and to do something about it now. I, through the magic of the internet, came up with an animation that I think sort of describes the way these cases start.
But we have a little bit of a problem.
Really? What's that?
One of our sales reps has done so well selling longboards that he has left the company and started up his own longboarding company.
What? This is unacceptable. We have a non-compete clause in all our contracts. How did you let this happen?
Listen, Cheryl, it's complicated. This sales rep felt that longboards are a whole new category that did not compete with skateboards.
Dave, longboards are skateboards, only longer.
I know that, Cheryl. But this sales rep felt they were a whole new category.
Jesus Christ, Dave. This really pisses me off.
I know, Cheryl. We are trying to serve this guy with papers to sue his ass.
Well, that's good. We should sue his ass.
So that's the way it goes. I mean, I've been part of those conversations, right? You're trying to, you know, longboards versus surfboards, and the most important, most salient factor is the business person is saying, sue his ass, all right? And you probably want to sue his ass at the point. You've seen the emails that they've written as they've left your company. But that's exactly the time, and I think in some ways this, I didn't talk to Joe beforehand about what his topic is, but I think that our message sort of dovetails, which is you're doing your job as an in-house counsel, and I think we do our job as our outside counsel by taking a moment right there before you go off to the races, before you go into court and get the TRO, and think about what the risks and benefits are of suing, and avoiding the sort of knee-jerk reaction of we have a non-compete, let's go to court and enforce it. The benefits of going to court are obvious. It sends a message, it stops the competitive threat. In discovery, what you fear is that the person who took your employee, the company that took your employee, is now going to be competing with you. Through discovery, you can actually learn things about what they're up to. So the risks are, the benefits are obvious. The risks are, I think, a little bit more subtle. You have to bear in mind that if you go to court, it's going to be a public matter. Depending on the size of the company you work for, it will be covered in the local press, perhaps regional, perhaps national press. Even if it's not covered at all, one thing you know for certain is the employees, your employees, are watching what happens. And you're going in for a TRO. Now, we as lawyers know that you can have facts that will be compelling at trial, and that you'll win at trial, but you'll still lose the TRO because the standard is so much higher. That's not, your employee doesn't know that. All they know is that they read in the paper that, they went to court and they lost. That non-compete might not be good. You can start to hemorrhage employees if you lose on the basis of a TRO. If your non-compete provision gets blown up, I've had a case before where my client had taken an employee who had a non-compete. This was a large company in Seattle. They had 2,500 employees. The court found that the non-compete was invalid. That had a huge impact on that company. I think that company would have thought again about whether or not it wanted to take that non-compete into court, because if you lose the non-compete, the value of your non-compete potentially across your entire case. Another thing is you have to consider what the costs are of litigation. These are very emotional cases, and who are your best witnesses? Your best witnesses are frequently your customers, who can say, who can speak to what the competitive advantage is that you're missing through the employee. You don't want to be dragging your customers into a lawsuit. So you have to consider all those risks and benefits up front. Now, I'm not saying, I recognize that this is trial.com. We're all trial lawyers. And I'm certainly not saying just pack up and you have a non-compete but don't enforce it. Obviously that's not the point. But at the outset of the case, you can frequently negotiate something that may be better than what you could get through litigation. Maybe you negotiate a standstill. Maybe you negotiate a non-poaching agreement. Maybe you negotiate a situation where the employee works in another part of the new company. But the time to consider that is at the outset, before everybody gets stirred up and they file a suit. So, but let's assume that you are in fact going to go to court. You have to focus on the complaint. The complaint in these cases is far more important than in the average case. I mean, in the average case, the complaint's just what starts it's what starts the case. But in a employee mobility case, particularly if you're going for a TRO, it functions as an opening statement, because you're going to be in front of a commissioner or a judge who has very little time to assess your facts. It's usually expedited. They've got 2 or 3 hours notice of your papers. Your complaint has to, in a very pithy fashion, outline the facts of your case and why you're entitled to what is some fairly extreme relief, preventing somebody from working. And your story the complaint has to tell the story. The story is not, we have a non-compete. I think that probably the number one defect that we see in these cases is an over-reliance on the non-compete. And that's understandable from business people or lay people who think, well, you have a non-compete. But I think we as lawyers know that instinctively, judges don't like to enforce non-competes. Instinctively, they like to protect somebody's ability to work. So it's not good enough to simply say that you have a non-compete. You want to make your story very clear that, look, we have secrets, this person has access to our secrets, and he's taken them away. And you tell that story with as hard-hitting as you can. Emails almost always are a treasure trove, because if an employee is leaving, what do they do? Well, what do all humans do? They sort of sell themselves a little bit to the company that they're going to. So they'll usually brag about what the clients that they can take with them. So you want to put those emails up front. You want to have affidavits from your own employees that talk about what the loss is. But you want to tell that story in the complaint. And I was trying to think of a good way of expressing that to you guys, and came up with, and I knew I'd be speaking in the morning hours when people are having breakfast and stuff, and there was a case, believe it or not, with Thomas's English muffins. Now, if you know those English muffins, what are they famous for? They're famous for the nooks and crannies. And they had a guy leave who was a very senior executive. He left and went to Hostess. Now, Hostess makes, of course, ho-hos and ding-dongs and many other delicious high-calorie treats. You wouldn't think of them as being in the English muffin business, but they wanted to get into the English muffin business. And their complaint was a perfect example. Tom's complaint was a perfect example of getting the judge's attention, because as it turns out, there are only 7 people in the world who know how to make the nooks and crannies. And this guy who was leaving was one of the 7 who knew how to make the nooks and crannies, and he apparently, before he left, used a thumb drive to take documents that talked about how to make the nooks and crannies. They highlighted that in the first page or 2 of the complaint. They got their TRO. That's an example of how you want to tell your story right off the bat. What are other filing considerations that you have to consider? Who do you sue? Your choices are: you sue the departing employee, or do you also add the new employer? Almost always, I am in favor of suing just the departing employee, because employees know that they have a non-compete, and they're waiting for that other shoe to drop. And when the process server shows up at their house with a complaint, and it has only them as the defendant, that's a very lonely feeling. And it's possible that you can, by doing that, you can pick off the employee right away. The new employer may not know about the non-compete, or may just decide that this isn't worth it. So in general, I favor, you can always add the employer later, but at the beginning, I think it makes sense to sue only the employee. Other things that you have to consider would be whether or not to go for injunctive relief. Usually you want to go for injunctive relief. I mean, it sends a message: if you're going to be aggressive, go ahead and be aggressive. But bear in mind, you want to have your ducks in a row, because the standard is very high, and as I've discussed, if you lose at the TRO, that can have some very negative consequences across your employee base. Don't forget a Uniform Trade Secrets Act claim. That's available in 46 of the 50 states, and the beauty of the UTSA claim is you don't need a non-compete. So if you are seeking to enforce your non-compete, and for whatever reason the court doesn't enforce your non-compete, the Trade Secrets Act protects your company's intellectual property even if there's not a non-compete. So you want to make sure that you have a UTSA claim in tandem with your breach of a non-compete claim. And then just to kind of finish off here, you get the TRO. And I think, assume you get the TRO, there can be a real temptation again, because these cases to be so emotional, to really sort of, put the boots to the guy, and to overreach with the TRO. You want to avoid that. It's a balance between continuing to be aggressive, making the company that took your employee feel the pain, which is that they're worried about having to engage in discovery where their competitive plans are going to be disclosed, but at the same time, not overreaching. You always want to have an exit strategy to, once you've sent the message, to be able to get out of the case. Okay, let's now switch gears and talk about defending your new hire. Shoes on the other foot. You've hired an employee. You know that employee has a non-compete. How do you handle it from that perspective? The first thing I would say, and it's remarkable to me how often this seems like obvious advice, but it doesn't always, is to be discreet. There is no need to issue a press release announcing the fact that you've taken on an employee. Bill Cronin and I had a case in Seattle recently in which, before we were retained, our client issued just such a press release in which they said, we've hired this person from a very large company in our state that does not enjoy being humiliated in the press. We've hired this person, and they're going to be doing exactly the same job for us that they were doing for this large company. We ate that press release for breakfast, lunch, and dinner. I mean, it was, you want to, discretion is certainly the better part of valor when it comes to these cases. Second, at the outset, take the very same pause that you would if you're enforcing a non-compete. Take that very same pause and think about whether there can be a way to settle the case. There's another client that we've had contact with that I think looks at this the right way. They view, they're involved in a lot of these cases where they hire people who may have non-competes, and they view it as a reverse acquisition. That's the phrase that they use. They've obtained the asset, and the question now is, what are they going to have to pay? The legal system is a way of of letting them know what the cost is really going to be for that employee. And that's the smart way to think about it. What is the cost, and can you negotiate that cost up front? Can you agree to park the employee in a different place? Can you agree to not poach other clients? There usually is a way to try to settle the case before everybody gets all stirred up. There's a secondary reason why you want to do that if you're on the side of protecting your new hire, and that is settlement discussions can derail a TRO. If you're involved in settlement discussions and they fail for some reason, it becomes much more difficult for your adversary to then run into court and say, I need immediate relief. As this judge said in a recent court, in a recent case in Delaware, the fact that you tried to negotiate a standstill, that's great, but if you think your rights are really being harmed to the extent you say they are, you have to go on a parallel path to get some judicial relief. You haven't moved fast enough, and I'm not giving you a TRO. So that's a secondary benefit that comes from these sort of upfront settlement negotiations. Okay, but let's assume there is no settlement. What do you do then? The key is regaining the offensive. The party that is enforcing the non-compete, the party that has gone to court to get the TRO, they've got the offensive. And the reason that those cases can be difficult is they've really got you on their heels. I mean, you've had no notice about the TRO, and you're sort of scrambling from that point forward. You want to regain the offensive, and there are several ways you can do it. The most aggressive way would be to file a lawsuit on your own, a preemptive strike, a DEC action that would be also filed with counterclaims. The other company is trying to interfere with your contract, your new contract with the employee. Obvious benefit of that is you get to choose the forum. And in these cases, forum really matters, probably more so than other cases. You can ask for aggressive expedited discovery. The other way that you regain the offensive is by telling your story. And from a strict story perspective, I think it's almost always better to be on the side of the employee, because that's a huge advantage. Any judge is going to see a company, typically a large company, or at least a company large enough to have a non-compete and lawyers and that sort of thing, that's trying to prevent your client, the employee, from working. So even if you're being paid by the new corporation, your client, and the story that you want to tell is the hardworking person who just wants to be able to earn a living. So that means when you're in court, you always want to have the employee's spouse. You always want to be telling the story that this is a person who simply wants to be able to work. You can continue to tell the story through the common defenses. I'm not going to take a long time here to go through what I think they're sort of well known, but always view those defenses through the prism of the story you're telling. Consideration. These non-competes are frequently blown up because there's insufficient consideration. Well, what does that really mean? What that means is, at the point that you're in court, the non-compete has a big value. It's obvious. It could prevent somebody from working. And ordinarily, they get very little in return for that. I mean, it's either there's no consideration at all or something very nominal. That helps you tell the story of this is a power grab by a big company that is treating somebody else unfairly. Geographic scope, they're almost always too broad. Length of time. A lot of times these non-competes were drafted 10, 15 years ago when 2 years was acceptable as a length of time. With the speed of technology and a lot of the cases that we do out in Seattle or in the tech business, 2 years, judges do not enforce 2-year non-competes. Even 1 year can be too long because of the speed with which the business moves. So you can almost always attack it in that way. Confidential information, it's never as confidential as people think it is. Final thing I would say, to sort of sum up that I think is a very effective tactic, is immediately get out your discovery. And as Joe pointed out, a lot of times we send out discovery, we don't know what we're going to get out of it. But here, you want the other side to identify what their trade secrets are. You say, hey, you guys are concerned about losing your intellectual property or your trade secrets. What are those trade secrets? You need to identify those with particularity. And the reason that you do that is, unless they identify the trade secrets with particularity, they can't get discovery from you. So that could put the plaintiff in a very difficult box in which they want the discovery, but they don't want to disclose the very trade secrets that they're trying to protect. So that's another way of regaining the offensive through discovery. I think that is all the time I have, and I appreciate your attention today. Thanks.